Hi everyone, welcome to part 5 of our employment law webinar series. Today we're going to be having a look at unions in the workplace. So my name's Nicole Howe, I'm the Managing Consultant with Liquid HR. So let's take a look at what we're going to run through today. So to begin with, we're going to have a look at the role of unions. We're going to have a look at the notice of the requirement to visit your workplace a union must provide and right of entry. We're going to have a look at the role of unions with enterprise bargaining, as well as the role of union representation as a support person if you're having any meetings with employees. So this is part of our 7-part webinar series, and the whole idea of this is to provide you with a quick snapshot and educate you on your requirements and ensure you have all the necessary knowledge to employ staff. So let's begin by looking at the role of unions. So unions act in a number of capacities, including advocating for employees to resolve workplace issues, acting as representatives in bargaining negotiations for EBAs, ensuring you as an employer are meeting your workplace obligations, and we'll talk a little bit about that later in terms of when they actually can come into your workplace to investigate a suspected breach. And then also looking for the suspected breaches of workplace laws, so that may be under the Fair Work Act, a breach of not meeting your award requirements or EBA requirements, a breach of discrimination laws and work health and safety laws. So the important thing to be aware of is that employees have the right to be a union member. So any employee has the right to join a union. They don't actually need to advise you if they are a union member or not. It's important to be aware as an employer, it's illegal to pressure an employee about the choice and whether they are a union member or not. And employees are protected from what we call general protections or adverse action, where it's illegal to take adverse action against the person for being or not being a union member, or taking part or not taking part in industrial activity. So when we talk about adverse action, what that actually means is adverse action would be something such as dismissing the employee because they're a union member. Or let's say, for example, you change their role to put them in a worse position. Or you may change their terms and conditions so that they're not better off because they are a union member. So if you do any of those things, an employee can make an adverse action claim to the Fair Work Commission where they have legal protections. With that in mind, so now you know that any employee can join a union, let's have a look at the right of entry of a union and when they actually can come into your workplace. It's really important you know what their rights are, but also what your rights are as an employer as well. So when we have a look at right of entry, to enter into a workplace, a union actually has to apply for a valid permit to be able to get a right of entry. Now they do this by applying to the Fair Work Commission. Once they have the permit, they may enter the workplace if an employee wishes to speak to them or if they suspect a breach in workplace law. So they must show their right of entry permit when they arrive in the workplace, and you can request to see that as well. In terms of the notice of visit, the union must give you at least 24 hours notice of when they intend to visit your workplace, and it also must be no more than 14 days in advance. There are some exceptions to this where the Fair Work Commission may give the unions an exemption certificate, and this is really under certain circumstances. It's normally only if they believe the employer may get rid of some evidence in regards to a suspected breach. So that's the only time they would actually change those timeframes. Of unions, when can they attend your workplace? There's really two primary reasons. One, to investigate a suspected contravention for a member. The important part here is it has to be for a union member. So they can't, if you don't have any union members in your workplace, they don't have any right to investigate that. Secondly, it can be to hold discussions with employees. So they're the two reasons why unions can come on site. When they do arrive on site, as I mentioned earlier, they must show you their permit, and then you can actually advise them where they can go. So you can agree on a meeting room that they can go into or the particular pathway they take to get there as well. So let's have a look in a little bit more detail around investigating a suspected breach and what unions can actually do once they come on site. So, in regards to investigating a suspected breach, if a union suspects a breach of the Fair Work Act, let's say a modern award condition, so perhaps they suspect that employees are not being paid the appropriate minimum wages, you're not paying the appropriate overtime, penalty rates, or if there's another employee entitlement that they think that you're not meeting, they can inspect any process or object related to that suspected breach. They can interview any person willing to speak to them about the suspected breach, provided they are entitled to represent that individual. And they can access records related to the suspected breach, including you must allow them to take copies of any documents directly related to the breach. Now, these documents would be documents that you hold in the workplace or on a computer. Really important here, permit holders, so unions, may only have access to the records of union members. The only time that would change is if the Fair Work Commission gives an order that allows union members to access records of non-union members. So yet again, really make sure that you're looking at that right of entry permit. When the right of entry permit comes through to you, which would normally be notified via email, if they're coming on site to investigate a suspected breach, the right of entry permit would state what that breach is and what they're looking into. So that can give you some time to prepare the documentation and get it ready so that you can take the union through it, ideally to be able to show that there hasn't been a breach. If you look into it and identify there has been a breach, then obviously it's your obligation to rectify that to make sure you're meeting the minimum requirements under an award or enterprise agreement. So that's the suspected breach side of things. The second reason a union can come on site in your workplace is to hold discussions with employees. So they're able to come on site to hold discussions with employees who perform work at that particular premises, whose industrial interests they're entitled to represent. So remember, unions cover a particular group of employees. So not any union can apply to any employee. Each union is set up to cover a particular industry, so you need to check whether they cover your industry. And thirdly, for employees who wish to participate in those discussions. So some employees may not wish to, say some may want to meet with the union. Really important here, and something employers often are unaware of, the meetings must not occur during the employees' work hours. So if employees do want to meet with the union and the union has a right of entry permit, yes, you do need to allow them on your premises. I always recommend giving them a meeting room that they can go to and showing them the way that they can walk to that. But if the employee wants to meet with the union, it should be before work, during their breaks, or after work. Really critical here, stopping a permit holder from entering. If a permit holder has followed all of the right of entry rules, so they've got their right of entry permit to come on site, you should not stop them from entering the workplace. It's really important that you allow them to come on site. If you don't, you can be fined under the Fair Work Act. So they're the main reasons around unions coming on site. Let's have a look now at unions. So we know with the Australian Industrial Relations System, the majority of our employees fall under what we call modern awards. Some organisations have what we call an enterprise bargaining agreement, and that's an agreement between that organisation and the employees that work there, specifically outlining the terms and conditions for those employees. Now, enterprise bargaining agreement would be an entire webinar in itself. But what we're looking at here is what role does a union play in regards to enterprise bargaining? So if you are negotiating an enterprise bargaining agreement with your employees, those employees may choose to nominate the union as their bargaining agent. So what that means is that you must actually bargain with the union around the terms and conditions of the agreement. As you go through the bargaining process, and there's so many rules that you need to follow through bargaining and timeframes, and it's critical that you get those correct. But if a union believes that you're not bargaining in what's called good faith, they can actually apply to the Fair Work Commission for a good faith bargaining order. And then at that time, the Fair Work Commission would make an order around what you actually need to do. In order to be a bargaining agent, the union must be able to represent the rights of workers covered by the agreement. So it comes back to, does that union cover the work that your employees perform? And that's always something that's really important to look at. So if you're not sure whether the union does, you can get in touch with us. We can have a look through that and work through that with you. The other part that I thought would be really important to touch on today is representation in performance discussions. So if you're having a performance discussion with an employee, whether it be around their performance or their conduct, you would know that we always recommend that you give them the right to have a support person present. The reason we do that is because if the performance discussion or conduct discussion ultimately leads to termination and that employee chooses to make an unfair dismissal claim, one of the things that the Fair Work Commission will look at is whether you unreasonably refused an employee's right to bring a support person to a meeting. So although there's not an obligation to specifically state you can bring a support person, it's best practice and we all advise that it's the best way to deal with it. But what you may find is you may have an employee who states that they would like to bring their union as a representative. That is completely fine. Make sure that you don't decline that the employee is allowed to bring the union. Some of the difficulties that we often face is employees will say, oh, but my union's not available for another month. I guess the reason what you need to look at then is, well, you can't wait a month to have the performance conversation with the employee. So you would then go back to the employee and say, we need to have this conversation within this time frame. Can you arrange somebody else, or is the union able to make somebody who's available? It's not an required expectation that you wait an entire month until the union is available. So with that being said, if a union is a support person for an employee, they would actually come in, you would hold the conversation with the employee, obviously going through your concerns. The question I often get asked is, what's the union's role in that meeting, or what's the support person's role in that meeting, and whether that individual can speak on behalf of the employee. There was actually a Fair Work Commission case, so the Victorian Association for the Teaching of English, in 2014, where it was confirmed that the role of a support person is to support and not to act as an advocate for the employee. So they're there to support the employee. They may ask the employee, or the employee may choose to pause the meeting so that they can go and consult with their support person. But the correspondence and the conversation that you're having is directly with the employee, and the union or support person is there to support that employee through that. With that being our snapshot around unions, there's obviously a lot more to unions, but really mindful of keeping these quick and short so that you can get the information that you need. Our next webinar is going to cover workers' compensation in New South Wales, so keep an eye out for it. From us, please do get in touch. That's our phone number on the screen, 1300 887 458, or you can always email us via inquiries@liquidhr.com.au. Thanks.